appearing with me for the president. Daniel Lola on the list.
Very well. Yes. Where are we in this case now? Yes. Very well. Memo, you ready?
Yes, sir. That's a good question. So we have that right to have it.
Do you have the agency? Give him.
Mr. Ebenezer, can you hear me?
Yes, I can hear you, sir.
Please, at the last I just did, you subscribe to our notes. That OT succeeds. You have to say the truth and nothing but the truth.
Yes, sir.
In essence, you have been reminded that you are still under oath.
Yes,
still
yes,
on
yes.
oath.
Yes, sir. Yes, sir.
Very well. The matter today is for cross-examination.
Yes, sir.
Mr. Henry, you can hear me.
Mr. Demi, you can hear me?
Yes, I can hear you, sir.
Okay. Just so that we are clear,
Okay.
you admit that the circumstances leading to your decision of your employment, termination of your employment,
Leading to?
the termination of your employment, was predicated on an actual attempt to defraud the defendant to the tune of over 20 million.
Right, sir.
Let me answer. I've not seen this.
And the statement made by management is that Mr. Adeyemi, you already admitted. So, and that's
Objection sustained.
My Lord, my understanding is that the witness will answer the question yes or no.
The issue is that throughout the proceedings there was never any place where there is that issue of admission. And at the same time, I looked into the implication of answering that kind of question. It's incriminating.
Okay, let me put it to him this way. Mr. Adeyemi, was there an attempt to defraud the defendant up to the tune of 20 million naira?
There was no attempt at
yes or no?
To no.
Yes.
He said no.
He said no.
I'll stop with this.
I said no, sir.
Yes. I want to refer you to your statement on oath.
Okay, sir.
Particularly paragraphs 13 and 14.
Okay.
Yes.
A moment, my lord.
Is it the father witness statement?
The first one, my lord. Sir Ademi, I want to read paragraph 13 to you.
I'm listening, sir.
Because I don't know whether you have a copy where you are. But in that paragraph 13, you said on the 27th of March 2014,
Okay.
while performing my official duties as a staff of the defendant, I received several telephone calls from the head office of the defendant around 7:30 a.m. wherein inquiries were made concerning the fleet cash transfer transaction carried out in the Ela Oregun branch of the bank on the 6th of March 2014.
Yes.
Please, do you recall making that statement on oath?
Yes, I made the statement on oath. And if you read further, hello?
The transaction you were referring to
Yes.
was an attempt to defraud the defendant.
It was not an attempt to defraud the defendant. It was a transaction which we did at Ilanogu branch, and the money.
Direct. That transaction you are referring to, was it an attempt to defraud the defendant?
Oh,
Yes.
capital no. Capital no.
He said no. He said capital no.
No. Oh, capital no.
Okay, thank you. So it is your testimony before this court. It is your testimony before this court that, to your knowledge, there was never any attempt to defraud the defendant.
Yes, there was no attempt to defraud the defendant.
I had yes, I didn't hear the.
There was no attempt to defraud the defendant.
He said there was no attempt to defraud the defendant.
Stop it. In your last cross-examination questions, you actually testified that you assisted in stopping that fraud.
In his last
cross-examination question before this course. You
examination in chief.
No, cross-exam. We asked 2 questions before my lord adjourned.
Okay.
So on that last date of cross-examination, you testify that you assisted in preventing that fraud.
I can't hear you, sir. Assisted in what, sir?
Did you testify on that last date that you were instrumental in stopping that fraud? In stopping the fraud?
No. In stopping the fraud, yes.
You have to choose one answer now.
I can't hear you clearly. I was instrumental in stopping the payment, not fraud, and of the transaction, not fraud.
Okay.
What is the answer?
He said he was instrumental in stopping a payment, not fraud.
Not fraud, yeah.
Yes.
Why was the payment stopped?
The payment was stopped because the customer in question was not present in the banking hall as at the time of the transaction to be paid.
The customer was
not physically present in the bank at the time the payment was to be made. So it was a transaction that required the physical presence of the customer.
Yes.
Yes.
Yet, as at the time it was stopped, in the absence of the customer, approval had been given for the payment.
No approval was given for the payment. If there is any approval, the money must have been paid. So no approval was given. The money was in the coffers
No,
of
thank you. That's fine. There's no approval. We're okay with that.
Yes.
Did you subsequently discover that the customer of the bank had nothing to do with those transactions? That they were not initiated by him?
I didn't get your question.
Did you later discover that the customer who owns that account was not the person who initiated those transactions?
The customer, the owner of the account cannot initiate the transaction because you are mixing it up. The customer that brought the transaction to us is a customer to the owner of the account.
So the question is, was it the owner of the account who authorized those transactions in his absence?
The owner of the account cannot authorize those transactions. It's a process.
No, you are not getting my question. These transactions, these transactions was about the payment of money, right?
Yes.
How much was involved?
I don't know of it. It's about 20 transactions.
How much money? You were a banker.
You said what, sir?
Cumulatively, how much was involved?
It's about 16 point something million.
So the question I was asking is that the customer was not aware, the owner of the account,
Customer, are you talking about? We have different customers concerning this transaction. We have the.
It should wait until when the question is asked. Witness, listen. Please listen to the counsel when he asks the question. Then you answer the question because I'm writing whatever you are saying.
Okay, sir. Okay, sir.
You are not only doing the conversation between you and the counsel. The court is recording you, and I need to get you very well.
Okay, sir.
Yes.
Thank you, my lord. So you are saying there are more than one person. So what I'm asking you now is that the owners of those accounts, they are not the one that initiated the transactions in the accounts.
Who are you referring to as the owner of the account, sir?
No, there's nothing I want to say. The man understands English. A bank that doesn't know who an account owner is, how clear can it be?
Somebody will to transfer. So you need to discuss it. The bank they're talking about
The approach my learned friend is adopting is just a way of telling the individual not to be answering my questions. I never work in a bank, but I know who an account owner is.
But even for me to get it very clear, you know, there is need to be specific.
Well, there are a person who owns an account in a bank. Is called a customer of the bank. He's also the owner of the account. So I use customer, I say he doesn't understand it. I say the owner of the account. He have testified here that it's about $16 million that was involved. He have testified here this morning that there are about 20 transactions. But the one he refused to understand now and saying the owners of those accounts where those transactions are done, the owners of the account where the transactions are done, were they aware that these transactions were being done on the account? It's a very simple question.
Let me explain, sir.
No,
the question you said, you asked this question, which is not yet answered. The customer / owner of those accounts are not the ones who initiated the transaction.
Yes, the same question I was trying to. That's exactly the question I wanted to answer. And everybody know how you initiate the transaction.
Have you gotten the question? Did you understand the question?
Yes, the owner initiated the transaction. The owner initiated the transaction. It's a third-party transaction. It is fleet cash transaction, not a savings or a deposit transaction. The owner initiated the transaction to another customer. It's like a money transfer transaction, like Western Union. The owner initiated the transaction to the customer, giving him all the details. Then the third-party customer now brought those transactions to our bank to redeem the cash. That is what I'm trying to explain. The owner initiated the transaction.
You have said that. You have said it. Yes. Are you satisfied with that?
Yes. Thank you. Let me just ask one more question to round up that angle. The owners initiated it, but you also had to stop it, to stop the owners from concluding the transaction.
As I've said, there are processes. You didn't let me explain the process. There are processes for this particular transaction. It is called a fleet cash transaction. It involves several processes. And we stopped the transaction when we discovered that none of the processes have been compromised.
What was compromised, please?
I have said the customer was not present physically to receive the money. That was why the payment was being stopped. At the point of payment, he was there to fill the form. He went back, and at the point of payment, he was not there physically to receive the payment. That was why the transaction was being stopped. And the money was in the of the bank, Bank PLC, Yelwa plan.
Thank you.
Yeah.
So, other persons who are not the customers were physically present to receive the money.
I didn't get you, sir.
You said that when you wanted to make that payment, why the customer was not in the bank to receive it. And now asking you, so other persons who are not the customers were in bank to receive the money. Because we're not going to pay to a PA.
There is no any other person. It is the account officer that was in the bank. There is no any other person. You cannot pay money to any other person.
Who was the recipient? Who was or were the recipients of the money. There must be a recipient.
Yes, I've forgotten his name. His name is there in the, this case was in the case we did, and the name was there. Olowo Okere somehow is the one of the recipients to collect the money, and is not there physically at the branch, at the point of payment.
So what we are telling the court is that 20 account owners of the bank initiated 20 transactions.
They are not account owners. They can't be account owner. It is a fleet cash transaction. That's what I'm saying. You don't have to be an account owner before you can collect a fleet cash money transfer.
Okay, thank you. I got that point now. But you said there were 20 transactions.
Yes.
You are saying that these 20 transactions would have required the physical presence of whom? Because you said account owner before, now you have changed. So the physical presence of who is required for these payments to be made?
The recipient.
So the recipient is different from the initiator.
Yes, they are different.
Yeah, so the initiator is the owner of the funds, right?
The initiator is an intermediary between the fleet cash and Thai Bank PLC. The initiator initiates the transaction on behalf of those recipients. And the recipients will have to come to the bank to withdraw this, to collect this money. That's how it works. It's like Western Union transfer.
Yes. So these transactions, all these 20 transactions, all these 20 transactions happen within an hour. Is that correct?
It's not within an hour. It's within a day. It happens on a particular day.
So is it your common experience in the banking sector where you were that there will be 20 transactions in a day that require the presence of the recipients, and in the 20 transactions, none of the recipients turn up? His experience as a banker.
Yes, certainly. He said he's a banker. He has stated the background of his profession. He's trying to tap from his experience.
He's not.
If a question about law.
The witness has been able to educate me on banking now, and all the while he was educating me, you never said that he should stop.
Let me ask this question. Is it to your common experience that there will be 20 transactions that will require what?
The presence of the recipients.
It's even more than that at
Wait,
times.
wait.
100 transactions in a
Wait,
day.
I've not finished the question. The court is writing.
Yes.
That require the physical presence of recipients, and in a day, and all the 20 recipients did not turn up.
I didn't get the question, sir.
I say, from your experience, it is the usual practice that in a day, there will be 20 different transactions where all the recipients will not turn up to receive the money.
It do happen.
In a day, 20.
It do happen.
Yes, we even have more than 20 transactions in a day.
No, thank you. Thank you. In paragraph 21 of your further statement on oath,
Okay.
you allege that it was a former colleague who printed the invitation to the disciplinary committee and sent to you.
It did not send to me. It gave to me when I visited the branch.
He gave you a physical copy.
Yes.
Sent him a physical copy.
Yes, they gave him a physical copy. Did you thereafter respond to that invitation?
I cannot respond to the invitation because the days have passed.
Yes.
Did you, from that time to the time you filed this suit, did you also contact your employer to inquire about that disciplinary proceedings?
I cannot contact them. I've been on suspension. I'm on suspension as at that time. So there's no way for me to contact them. The last official letter I received was to go on indefinite suspension pending the outcome of the case.
I will have to get you, right, with your question. Did you contact your employers about the disciplinary
proceedings or hearing?
I cannot contact them.
After receiving the invitation?
I received the invitation months after the date on the invitation. And there is no way I could contact them because I have been on suspension. The last official letter I received was for me to go on indefinite suspension pending the outcome of the case in court. The letter is there as my evidence.
Yes.
So the invitation that was given to you, that you said was given to you by your colleague, they had other of your colleagues, a copy, who were also invited to sign. Yeah.
Hmm?
I didn't get you.
That he alleged that was given to him by his colleague had a copy. Other colleagues who were equally invited to the DC, disciplinary committee.
What's your reaction?
I didn't get the question.
You made a statement. He made a statement to you. Repeat that statement you made to him. So that
Testify that you were given a physical copy of that invitation by your colleague. And you say in that invitation, other colleagues of yours who were equally invited to the necessary committee were copied in that email. There were other names other than your own in that email.
Yes, yes, yes.
You are aware that those other persons attended the necessary committee.
I don't know. How will I know? I don't know. I don't have any business with them.
yes.
In paragraphs 4 and 5 of your further statement of oath, you refer to a purchase and assumption agreement.
I can't hear you.
I think in paragraph 4, paragraph 10 in particular of your further statement of oath. Okay, sorry, paragraph 4. Paragraph 4 of your further statement of oath.
Not including 5.
Yes.
Because you said in your in paragraph 4 and 5 of your father. Yeah.
4 and 5.
Yes.
Yes. You refer to a purchase and assumption agreement dated 21st September 2018.
Yes.
That purchase and assumption agreement was between Polaris Bank and NDIC.
Yes, yes.
The time you left the employment of the defendant,
Well, the network is getting bad.
can you hear me?
I can't hear you. What do you say, sir?
I said, when you left employment, it was the bank you work was not as Sky Bank PLC. Is that correct?
I work with Sky Bank PLC.
Yes.
But the answer is yes.
Yes, you work for Sky Bank.
Very well. Any re-examination by 11th Council? position now. The claimant has closed his case.
We only apply for it's not there too. We only have just one witness. That's to bring it up. So I'm not looking for
Witness, you can step down. Thank you very much
Wow.
for being with us.
Thank you, sir.
What date do you think will be convenient to you? But it has to be 2025.
if my husband will just sit there and see whether
How many witnesses are you going to call for the
Just
defense?
one.
One. So there is a likelihood that you are going to close the case for the defendant as well that day. Counsel, will you close the case that day?
yes, ma'am. But my husband, I don't know whether the court can apply just with 19. I'm going to try around 15, even though it's before NIC. My 19 is also fine.
Clement, is that 19th? Is it convenient to you? It's convenient. By the concurrent agreement of council, this case is hereby adjourned to the 19th day of February, 2025 for defense. Very well. Yes, actually, you are granted. You can follow suit. Yeah.
Speak up, Mr. Richard.
Nobody's asking me anything. If somebody's speaking, the person is on mute. So I can't hear
Your name
anybody.
was called. You are supposed to say present, sir.
Okay,
You are
I didn't
supposed to
hear.
indicate that you are in court.
I am present, but it looks like if that's Redmi talking, Redmi is on mute. Redmi, unmute yourself because I didn't hear her say my name. Barrister Femi, if my name is being called by Redmi,
May I, with profound respect to my noble lord, Femi Abimbola is my name, sir. I appear for the claimant, sir. My lord, I'm with my learned friend, Abraham Obijama. Obijama, my lord. Obijama is spelled Obijama, my lord. Yes, my lord. Yes, my lord. It appears they are not in court. But I'm sure the matter was adjourned till today in the open court. They did not tell us the reason why they are not here. Yes, my lord. It was for ruling. My learned friend just told me now that it was for ruling and they were not in court. In all fairness to them, sir, we are not in possession of that fact. Yes, my noble sir. We are grateful, sir. Yes, my lord. Yes, my lord. My Lord is correct. Correct, sir.
They were never to go this boat anymore. Despite the substitution of this whole port, and the substitution of that. Yemen port. Yes, what is the position? Mr. Femi,
Yes, my noble Lord, sir.
actually it appears we are constrained really because there is no proof of service of the hearing notice in respect of today's sitting on the defendant's counsel. So you see, and this goes to the root of this matter.
I agree, my Lord.
It's so fundamental, and we cannot just continue or we cannot proceed with hearing of this matter.
I agree, my Lord.
Because anything we do is going to be in vain.
I agree, my Lord.
So in the circumstances, I think it is worthy doing. We take an adjournment. You take an adjournment, I will grant it to a more convenient date where the counsel for the defendant will be duly notified by way of hearing notice being served on them.
As copy as my Lord.
Witness.
Yes, my lord.
Yes, you are welcome. The proceedings would have conducted the proceedings today, but my discovery from the case file that I have realized that the defense counsel is not notified of today's sitting, and there is need for him to be in court for the proceedings to be conducted. So in the circumstances, I will grant an adjournment for your counsel, and I will give you another date.
Yes, my lord.
We will be getting back.
Yes. Can you be here on the 19th of February?
February.
18th is much more convenient.
18th of February.
Yes.
We will be here, my Lord.
Very well.
We agree to, sir.
Very well. in view of the fact that the defendant's counsel was not served with hearing notice with respect to these proceedings of today, this matter be and is hereby adjourned to the 18th day of February 2025 for trial. The defendant's counsel be issued and served with hearing notice before the next adjournment, and copy of which shall be filed in the case file. Any other thing? Witness, you can step down.
Thank you, sir.